These two faces must be familiar to you. Uber and Lyft faced tough questions from California judges as they seek to keep classifying drivers as contractors. So let's dive straight into this story. A California appeals court heard arguments on Tuesday from Uber and Lyft as they appeal a recent ruling that would force the companies to reclassify drivers as employees. A lower court determined in August that Uber and Lyft drivers are employees, not contractors, under the state's gig work law AB5, but delayed enforcing the ruling while the companies appeal it. Uber, Lyft, and other gig companies have fought AB5 aggressively, pouring more than 180, it's actually 200 million, into a ballot measure aimed at California voters that would permanently exempt them from the law. The companies argue reclassifying drivers as employees will reduce their flexibility, while proponents of AB5 say Uber and Lyft's business models rely on underpaying drivers and skirting labor laws. So a California appeals court heard oral arguments Tuesday from Uber, Lyft, and the state over whether a lower court reached the right conclusion in August when it ruled the company's drivers are employees under the state gig work law AB5. Judges from California's First District Courts of Appeal pressed lawyers for Uber and Lyft over drivers' wages and autonomy and questioned the company's arguments that AB5 would require them to reduce drivers' flexibility, according to the Washington Post and New York Times reporter Kate Conger. The judges also asked a lawyer for the state about potential harms to Uber and Lyft and drivers' preferences around the employment status, according to reports. The landmark case could fundamentally alter the contractor-based business model that Uber and Lyft have relied on, and the companies are aggressively fighting the law in court and via a ballot measure that California voters will decide on in November. AB5, which went into effect at the beginning of this year, allows companies to treat workers as independent contractors instead of employees only if workers meet three criteria. They're free from control and direction of the company. They perform work outside the usual course of the company's business, and they're customarily engaged in their own independent business. So what too many drivers misunderstand, they believe, and this is what they're being spoon-fed by Uber and Lyft, that they are independent contractors. You are so far from independent contractor status, right? So AB5 pushes it in the right direction. California state and city attorneys general sued Uber and Lyft in May over the refusal to comply with the law, arguing that ride-hailing drivers don't pass that test. San Francisco Superior Court Judge Ethan Schulman sided with the state in August, ruling that Uber and Lyft must reclassify drivers as employees, but the ruling was stayed by Schulman and again by the appellate court while the companies appeal. In Tuesday's oral arguments, Uber lawyer Theodore Boutrous Jr. argued the ruling would cause irreparable harm and that Uber would have to turn into a different company and cut jobs if the ruling is upheld. But according to Conger, Judge Brown questioned Uber on that claim, asking what part of AB5 would require the company to reduce drivers' flexibility. Uber and Lyft have focused heavily on flexibility and their opposition to the law, citing drivers' alleged preferences to work as contractors, but critics of the business model say it allows the companies to cut costs by depriving drivers of protections like minimum wage, health insurance, and unemployment insurance, and other California workers and unemployment insurance that other California workers are entitled to. Matthew Goldberg, a lawyer from the San Francisco City's Attorney's Office, responded to a question about drivers' preferences by saying employees should not have the right to work without those underlying benefits. You are not permitted to work for less than the minimum wage, even if you want to. When pressed by the judges on potential harms to Uber and Lyft, Goldberg responded that every other company follows the law, so Uber and Lyft should have to as well. He also said Uber and Lyft were causing harm to drivers. This is dollars and wages and money that is being stolen from drivers by virtue of the misclassification and from the Californians because you're fitting the bill, right? So Uber and Lyft have reportedly claimed that the law doesn't apply to them in the first place, an argument Lyft lawyer Rohit Zingler brought up again on Tuesday, while Boutros cited changes Uber has made to its app that should exempt its drivers, according to the Washington Post. But the judges appeared skeptical, pointing out that Uber still sets the base fare for drivers, right? So you don't get to set the fares, they set them. They also cast doubt on Lyft's claim that underpayment of drivers' wages isn't irreparable harm, according to the Washington Post, with one asking, are you suggesting that the specter of thousands of individual claims for back wages is something that is insignificant and something that need not be considered in balancing the appropriateness of an injunction at this point? California's Labor Commission brought a separate lawsuit against Uber and Lyft over the same issue in August, alleging they've been committing wage theft by classifying drivers as contractors. And guess who picks up that tab? Californians. So Californians vote no on Proposition 22 in November. You shouldn't be bailing out these companies all the time. Uber and Lyft have sought to head off a potential loss in court by pouring more than $180 million into the ballot measure, Proposition 22, that would exempt ride, hail, and food delivery workers from AB 5. That's the most money ever used to back a ballot measure in the state, according to Ballotpedia. Uber and Lyft also came under fire earlier this week after SF Gate reported that the companies indirectly funded ballot guides sent to California voters urging them to vote for Proposition 22 by falsely claiming to be affiliated with Senator Bernie Sanders and other progressive groups. Both Senator Sanders and the California Democratic Party have opposed the measure. So there it is. You know, they're in for a tough time if they want to get through this. These two stooges here. Please like, subscribe, share the video. A big shout out to my sponsor Kover, Kover. The link is below. You get 1 month free with this gig protection plan. You should have it in place, just like you have your auto insurance and medical insurance. These protection plans start at $7 a month. If you get deactivated, they have legal rideshare kick in, send off the legal letters, get you back in the game. If you end up in the hospital, if your car ends up in the body shop, that Kover kicks in and gets you 80% of your lost salary. Now, legal rideshare should be the one and only law firm to turn to. They specialized in injury, property damages, and wage loss. So if you have any issues, if you had an injury, an accident while driving with Uber, Lyft, Uber Eats, DoorDash, Grubhub, contact Legal Rideshare, right? The websites, the links are below. They will go out, file the suits, fight for you, and get you what you deserved. So wishing you a great day. Please feel free to leave your comments, and thank you again.